Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. I'm a rule follower, and it annoys me when lawyers and courts do not play by the rules. One of the hardest habits to break as a new lawyer is asking leading questions on direct exam. And that's because you've lived with this case for more than a year usually. By the time you get to trial, you know what all the answers are, or at least what they're supposed to be. If you frame your questions that way on direct exam, however, you're going to draw an objection for a leading question. Now, a leading question, of course, is one that suggests the answer. You were at the party on January 4th. Yes, I was. Anything you can answer with a yes or no is going to be a leading question. On the many things like foundational matters that are not critical, you can get away with it. You can say, you're a police officer, right? Yes, I am. And you were on duty the night of August 11th, 2021. Yes. Now you have to move to the open-ended questions. Did anything happen that evening that was particularly noteworthy? Yeah, I was called to the scene of a murder. And where was that? And then you ask the next questions. What happened next? What did you do then? What you don't do is narrate for the individual. Now, the rule against leading questions on direct is designed so that the party with the burden of proof cannot play the witness like a violin, using loaded questions and getting emotional answers. For example, Mrs. Smith, you were married to your husband for 30 years. Yes. And you loved him. Oh, yes, I did. You never looked at another man during that entire time. That's right, I love my husband. Then the man over there, the defendant, he got drunk. He got in a car. He barreled down the highway at 85 miles per hour, and he crashed into your husband. And you had to go to the morgue and identify his dismembered body, didn't you? Yes. And you can see where you wouldn't want somebody to be able to get away with that on direct exam. But lawyers can get the same emotional weight of the testimony, and maybe even better, when they let the witness tell the story in their own words. What were you doing at 11 o'clock that night? I was waiting for my husband to come home. And what happened? I got a call from the highway patrol. And what did they say? They said my husband had been in a terrible accident. And what did you do? Well, I asked him what to do, and he said to go to the hospital. So did you do that? Yes, I did. And when I went to the hospital, I went in and they told me I couldn't see my husband. Do you know why you couldn't see your husband? Well, they said that he had been decapitated. Things like that. You can actually get a better emotional response from your client, usually telling the story, than you can from leading her through with all of those theatrical kinds of questions. And I think it's organically more persuasive if it comes in, or the emotion anyway, if the emotion comes in from the witness and not from the lawyer. In criminal trials, leading questions are even more problematic. The state has a man on trial, and at risk is his freedom for the rest of his life. Now, you ask these questions, and I can understand letting them get away with the foundational questions. You're a cop, right? But watch how the prosecutor, in the context of taking accountability for a mistake, testifies for the officer in this segment.
Let me first apologize for you having to be here, because I'm going to take responsibility for it. Okay, you're an extra witness to clear up a mistake from yesterday. Okay.
Yes, sir.
How are you employed?
I'm employed with the Memphis Police Department.
The first question was leading. The second question was an open-ended question. That's how he should be doing it, but that's not what happens.
Did you have occasion to work on the case having to do with the murder of Adolph Thornton Jr., the rapper known as Dolph?
Yes, sir.
In particular, on November the 24th and then on November the 26th of 2021, did you have occasion to go to the Crosstown building?
Yes, sir.
Did you speak with security there?
Yes.
Were you allowed to view video there?
Yes, sir.
Did you retrieve video from there?
Yes, sir, we did.
And was it accurate surveillance footage from the building
Yes, sir.
from November the 16th and November the 17th
Yes, sir.
of 2021?
Yes, sir.
And was it one camera angle or many camera angles?
Many camera angles.
In fact, November the 26th, I'm looking at your supplement, you actually created a timeline of the various events that you witnessed on the surveillance tape, is that correct?
Yes, sir.
With the hour and the minute, and then what you observed.
Yes, sir.
When a witness is saying yes all the time, that's a leading question. He should have asked, what did you notice about the timestamps, if anything? Tell me, and then, well, tell me what you concluded from that information, so that he could let the witness testify about the conclusions that the witness reached, not just hand him the conclusion like somebody getting a burger from McDonald's. Now, I can't be sure, but with Luke Evans being a very skilled lawyer, the only thing I can think is that these folks have made an agreement. In order to move the trial along at all deliberate speed, the parties have agreed not to object to leading questions. That's really the only explanation for this, because there's been so much leading from the prosecutors in this case. Now, that could be a strategic choice for the lawyer. A skilled lawyer knows how to do a good direct exam and can find a way to ask questions in such a way as to get the answers from the witness that he wants. And more importantly, when the defendant's counsel is jumping up every 5 minutes and yelling leading, it looks to the jury like, wow, the defense has a lot to hide. And then, of course, when the information comes in anyway, it's obviously more or less a fool's errand in some cases. Now, in this case, after having cleaned up the error, the prosecutor sat down and Mr. Evans got up and again sowed the seeds of doubt with his cross-examination questions.
And I'm sure in your long career in law enforcement, you've collected a lot of surveillance video.
Yes, sir.
From different locations. And you would agree with me that it's not uncommon for surveillance video timestamps to be inaccurate.
That's true.
Right? And I think you said the way that you went about trying to confirm accuracy was by looking at the time when you were there and looking at the video and saying it was the same, like those times matched. If you're there on the 24th at 2 p.m., you looked up at the system and it said on the video it was the 24th at 2 p.m.
Yeah, we compared the live view.
The live view.
Yes, sir.
But you would agree with me, you weren't watching the live view on November 17th or November 16th when these concourse videos were actually being recorded, correct?
No, we were not.
You're going back and reviewing an archived video format of those, correct?
I'm sorry, man.
Yes.
Yes.
Right.
Yes.
And truth be told, you can't, whether it was the live view was accurate, right? You can't say whether it was accurate on the 17th, right? Because all you did was look on the 24th and go, oh, watch says it's 2 p.m. on the 24th. I'm making up that time just as an example. And the live view shows it as 2 p.m. on the 24th. Therefore, this must be accurate. That's right.
Yes, we use a live view to check and see if the cameras were accurate during that time before we did the bookmarks.
But that test alone doesn't tell you whether or not it's accurate on November 7th 18th and November 16th. You would have to agree with me, right?
Yes.
So it looked to me like he did a really good job of pointing out that there is just an assumption that the timestamps are okay. And in addition to making assumptions about the timing of the videos on the 16th based on the timing present on the 24th, the detectives in the case made a number of other assumptions. Every witness, or so it seemed, kept talking about that Bass Pro hat. Do you have any idea how many Bass Pro hats there are in Tennessee? That hat is ubiquitous, and the hat obscures the facial features, which is probably what it was intended to do, and so you can't make out the face. Many of the videos are shot from the rear, like the ones from the elevator there. And with a slight turn of the head, you can see the Bass Pro logo. The Bass Pro hat is the key to the government's case, or at least one of the keys. The problem is that's not the only hat like that in Tennessee. That alone is reasonable doubt. But far and away, the most illogical and attenuated identification, and I use that word very loosely, was this one.
Yeah, you can see.
Charge just sort of repositions when this man came outside, is that right?
Yes. Came out up the rear of the
You're interested in this man?
yes.
Sweatpants?
Sweatpants, black shoes, white soles on. Leaning into the car.
He's got bags or something
Yes.
now.
See how his pants are sagging there a little bit. We have that was something that we looked at also.
In the homicide video, as he runs away, we can see his pants are sagging.
Yes,
Can we, in fact, see the color of his underwear in the homicide video?
yes,
Is it also blue?
yes.
Do you know how many men have the same color of underwear like that? Anyone who has ever purchased these same drawers at Hanes Outlet, Sam's Club, Costco, Walmart, Target, Dollar General, any of those places. Come on, the shooter had on blue underwear and this guy does too? Who cares? I don't care if he's got a drawer full of blue underwear, because I'm sure there are a lot of other people all over the South who also have on blue underwear. On that day in Memphis, probably 800 other men had on the same color of underwear. Now, all of these things are just more food for the stem winder that will be the defense closing argument in this case. And I'm really interested to watch that. So they are going to be very interesting. They're going to be lit. We'll cover those in a video as well. So that's all I have for you today. Thank you very much for watching. If you have the time today, do something nice for somebody. Doesn't have to be a huge thing. Just maybe, buy somebody a soda while you're out at lunch. Bring it back to the office. Treat somebody to something that's a treat for them, because in essence, it's a treat for you too. Thanks for watching. Come on back tomorrow. Join me down here at the beach, and we'll talk about something else fun. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.